Hey guys, my name is Attorney Walter, if not the third, and I'm with Disability Resolution PA. The video we're going to be making is, will they, in the near future, change the 5-month rule? What is the 5-month rule? Well, basically, there's this 5-month waiting period, and it just is terrible. It was a terrible idea back in the day. It's an even more terrible idea nowadays, considering what's going on with COVID. But the bottom line is this. The 5-month waiting rule is where if you're applying for Ssdi benefits, disability benefits, for 5 months, okay, they don't have to pay you any of those as back pay. They don't have to pay you any of those as forward pay. In fact, you'd have to wait to go ahead and start receiving after that 5-month wait period. And I know what you're thinking. Well, wait a minute. When I'm found disabled, let's just start getting money. Yeah, that makes sense. There's arguments against and for the 5-month waiting period. We're going to go over both. We're actually going to go through specifically the Congressional Research Service. This person right here created this document, and because I don't usually create scripts for any of these videos, I'm going to use this as kind of like the script to keep me on track. Now, here's kind of the focus of this entire video. What is it? We're going to go through this. Who's trying to get rid of it, and where's it right now? And does that mean ultimately more money for you guys in the sense of those who already have benefits, those who are about to get benefits, those who are just applying right now? Let's begin. As you guys know, once again, I'm not a talking head. I'm not a radio person. I'm a practicing professional within the Social Security disability field. Let's go ahead and begin. Let's read the summary first. Social Security Disability Insurance, SSDI benefits, that quarters of coverage program for disability benefits, is authorized by Title II of the Social Security Act and provides income replacement for eligible individuals who are unable to work due to long-term injury or illness as expected to last at least 1 year, think 12 months, or result in death, think terminal. Current eligibility requirements include verification of an applicant's disability, filing a claim, a recent work and duration of work test, verification that an individual has not reached normal retirement age, and a 5-month waiting period from disability onset. So the last one is the one we're focusing on. They broke it down into little things. So let me just break that up real quick. Number 1, verification of an applicant's disability. So where the medical professionals have to say he's got it, it's severe. Number 2, you got to file a claim, otherwise they don't know to actually begin the process for you. Number 3, a recent work and duration of work test. So what that means is that you have to have worked and earned 20 quarters of coverage within the past 10 years. If you're not sure what a quarter of coverage is, just look it up online, but basically you can get 4 of them per year, and you need a total of 20 within the past 10 years. That's that whole test. Number 4, verification that an individual has not reached normal retirement age. They're looking at that. What they mean by this is full retirement. They mean like, you've reached the end of the road, because normally you get onto SSDI benefits and you ride that to full retirement. That way you don't have to take early and get penalized. And 5, a 5-month waiting period from disability onset. So when you file, there's 5 months. There's 5 months that don't count for you, which is what they're trying to get rid of. All right. I have random pages here. I'm not sure why. All right, there we go. All right, next thing. In implementing the 5-month waiting period for SSDI benefits, Congress sought to set a time frame that would be long enough for a short-term injury or illness to be corrected, but would also deter individuals who can work from applying for benefits. The first month counted as part of the waiting period can be no more than 17 months before the month of application, and benefits can be applied retroactively for up to 12 months. The Social Security Administration encourages eligible individuals to apply for benefits as soon as possible after the onset of a disabling condition. All right, there's a lot in there. If you don't know what this field means or what this stuff is, all of that was completely, ridiculously, just mind-numbingly not able to be approached, understood, any of that. Let me break it down for you. In implementing the 5-month waiting period, all right, so we're talking about this 5-month. You file, you got to wait 5 months to be able to get benefits. For SSDI benefits, Congress sought to set a time frame that would be long enough for a short-term injury or illness to be corrected. So what they're saying here is, okay, so you file, and we know that there's enough time here, there's 5 months here, where we can wait, the SSA can wait to see whether or not you are going to get better from the impairment that you had when you filed, right? Some impairments are easy like that. You're in a car crash and boom, we know the impairment happened on this date. Some impairments are tough, like depression. Like, when did it start? 3 years ago? 10 years ago? So they set aside 5 months. That's one of their arguments, pro 5-month waiting period, to make sure that you didn't have a short-term impairment that was severe, that would ultimately become moderate or mild, but rather they're looking for those impairments that are going to continue to be severe, okay, past the 12-month waiting period. That's that whole 12-month rule. Okay, so blah, 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 but would also deter individuals who can work from applying for benefits. Now, this was not one of the original reasons they came out with, because remember, when they first came out with this rule, it was in like the 1950s, and people had just a couple of decades before started to pay into the government, federal taxes for this whole Social Security idea. So kind of the bottom line is they would not have punted with the idea that we think as Congress, you Americans are lazy liars. They would not have punted with that particular football, because that would have pissed off people from the 1950s oh so bad. So let me read the sentence again. But would also deter individuals who can work from applying for benefits. Okay, so they're saying that, look, there's those people who would become impaired, and because they need money and fear from being homeless, this 5-month waiting rule would make them fear being homeless enough to go back to work. Even if it's medically against what they should be doing, this 5-month, you can start to see why this is a terrible idea. This 5-month waiting rule would make the injured person go back to work. Forget the idea that, it takes forever to get on disability benefits and yada yada. It took less time back in the day, and then it took a horrendous amount of time. But, it's still horrendous nowadays, but not nearly as bad as it was, 10 years ago, because the waiting periods were really bad for ALJ hearings. But just think about that. Like, let's say, you get in a car accident in January. They're saying here, but would also deter individuals who can work from applying for benefits. They're saying here, if we put this 5-month waiting period in there, then we're going to let that person, just dangle a little bit. We're going to let them dangle on the hook a little bit. See if they go back to work. Yeah, maybe they'll go back to work. Maybe they're not so bad. Maybe they're just moderate. I mean, they could be severe and then kill themselves going back to work to not become homeless, lose their mortgage. They could do that. But maybe they're not that bad. Maybe they're just mild. Maybe they're just moderate. Maybe the thing that prompted them to file for disability benefits wasn't that bad. Wasn't that severe. And there's a lot of people that do that. They're only moderate or mild and things like that. And they apply for disability benefits. But just think about the ethical issue here of, all right, we're gonna give 5 months for this person to just kind of dangle, not have any money. Of course they've got car insurance in the 1950s to cover them. Of course they've got workers' comp, short-term disability benefits, long-term. Of course they've got that when we're coming out with Ssdi this year. You can start to see how awful this idea was in the 1950s, because none of that stuff was really figured out at that point. All right. Anyways, let's go on to the next one. I love doing this stuff where we get to go into the history of what the government was thinking, and God, they were not moral people. They were immoral, unethical. God, that was their motto. But let's have fun. The first month counted as part of the waiting period can be no more than 17 months before the month application. All right, so what they're talking about here is if you file on this date, you got to wait 5 months. Or if you can prove going backwards in time that you became disabled at some point, these are called retroactive benefits. You file, you're found disabled, back pay benefits. You file before you filed, retroactive benefits. These retroactive benefits, you can go back 17 months, right? So that 5-month waiting period could be way over here. And then you could potentially get back, or retroactive benefits, actual money for essentially 12 months. Because remember, 17, we get rid of 5, 12 months, and then we're at the filing date. So you might be able to go back that far. Now, if your car accident happened and then you filed, you're getting screwed out of your, the 5 months is going to be like right there. But if you didn't file, and it was a while ago that the car accident happened that made you severely impaired where you couldn't work, then in that instance, you could go ahead and apply those 5 months. But then think about this from a moral ethical stance. Why would we create this rule for somebody who was unable to file for disability benefits? They didn't know about it. The program's new. It's the 1950s. The internet isn't flashing stuff all over the place. The person was horrifically injured. They're not mentally of sound mind, so they're relying on other people to file them for all the programs that they need, and they might not know about them. You're starting to realize this is a god-awful rule. How did they come up with this? Were they just sitting there all right, here's the plan. We're going to save this much money and screw over the people. How are we gonna make this much money off of the injured, off of the disabled? Here's what we'll do. We'll create the 5-month waiting period. Oh, it's brilliant. Oh, it's like Christmas, but the opposite. All right. So the first month counted as part of the waiting period can be no more than 17 months. So now we know we can go 17 months back before the month of application. All right, that's our filing date. And benefits can be applied retroactively for up to 12 months, right? So we know if we go 17 months back, we take off the 5, we've got 12 months of potential retroactive benefits. Our date of filing, found disabled, forward pay, back pay, retroactive benefits, okay? I know my hand signals are amazing. I appreciate all the people who comment on that. And benefits can be applied, okay, blah, blah. The Social Security Administration, SSA, encourages eligible individuals to apply for benefits as soon as possible after the onset of a disabling condition. How would you know that? Has the SSA ever really reached out to you and said, if you get injured, you should file right now? Somebody who's in the field, I have never seen an advertisement that was at the level needed to notify people as to what's going on. In fact, the only reason people know to file for disability benefits is that so many people in America are on disability benefits. There's a bunch of attorney advertisements for disability benefits, and I don't make advertisements. I make tutorials because I think the advertisements are stupid. Like, hey, you know what you guys should do? You should trust me because I'm honest. I have integrity. I'm honest. I'm knowledgeable. I'm also honest. You can have my cell phone. That's how those are to me. I mean, wouldn't it be a cooler idea if attorneys shared their knowledge of what they're doing to get people? And I understand that some people are like, oh, whoa, you're giving everything. No, you're not. You still need somebody there to cross-examine somebody. You still need somebody there to write the brief. There's all these parts of the process that it's just, you can't have somebody not there to do it, That's a different argument, different day. All right, let's go on to the next thing. The waiting period does not apply to individuals who have been previous recipients of SSDI in the 5-year prior to any current disability. All right, so let's say, now this is an important sentence. Let's go through this. There's a caveat to this 5-month waiting period. We're going to screw you over with it the first time, but if you were on benefits within the past 5 years prior to the current disability, then you don't have to wait. We're only going to get you once recently. Unless you're like 5 years and a month, then we're going to get you again. We're going to screw you over again. All right. The waiting period does not apply to individuals who have been previous recipients of SSDI in the 5 years prior to any current disability. In the 5 years prior to, so if you lose your benefits within 5 years, right, but then regain them. Okay, so 4 years and 12 months ago, you had them, and then boop, you get them again. Guess what? Life is okay. You don't have to wait for the 5-month waiting period. Several other programs, such as Supplemental Security Income, SSI, yada yada, temporary disability insurance, workers' compensation, unemployment compensation, and private disability insurance can provide funds for eligible SSDI applicants facing financial hardship during the 5-month wait period. So here's where they're trying to sell you that we have other programs in place if you paid for the insurance, if you were injured on the job, if you have a child. But most of them don't fit into the if you're homeless and can't even find a way to apply category. And that's the thing. SSI, it takes a really long time to get onto that, just like SSDI, for most individuals. Some people it's really quick because they're really severe. But most people, so when you say, oh, SSI, homeless people, that'll take care of them, most claims for SSI and SSDI are decided on the same day. So this argument that, hey, SSI for these poor people that haven't worked enough, people who have never worked, I'll just go on that first. No, buddy. Most SSDI claims and SSI claims are decided on the same day. Or the way that works is somebody won't have enough quarters of coverage and they'll get their SSDI denial first, and then they'll have to continue with their SSI claim. So that's a pretty much horrifically terrible argument on behalf of the government. And it's not necessarily the government, it's this person right here who is creating this on behalf of the government. So, and remember, these are quick sheets for senators. That's what these basically are. They're quick sheets to go and show people essentially how this program works. All right, let's go over to here. Several other. All right, so This report explains the 5-month waiting period and its legislative history and will be updated to reflect legislative activity. It's a quick sheet for senators. Okay, let's go over here. And remember, I use these because they keep me on track. Otherwise, as you know, I can go all over the place. The 5-month waiting period for Social Security disability insurance benefits. We are now on page, well, we're actually on page 1. We were just reading the summary before. Title 2 of the Social Security Act provides that certain individuals may be entitled to Social Security disability insurance benefits under the Federal Old Age Survivors and Disability Insurance Program if they meet the following statutory requirements. The individual's medical condition meets the definition of disability as specified in Section 216 of the Act. That whole thing is about, is your impairment severe enough, or the combination of your impairments, totality of the circumstances, all of your impairments, if those are severe enough or prevent you from working, okay? A full-time job. Number 2, the individual has filed a claim for disability. So did they file? Okay, they filed. The individual is insured generally requiring either a work history or the work history of a parent or spouse as specified in Section 214 of the Act. Okay, so SSDI benefits come in 2 flavors. Either you worked it or somebody else that you're connected to that you can draw from worked and paid into the system, right? So it's not just always you who worked it, worked the hours, got paid taxes on that money. Sometimes it's other people. For example, like a parent, or maybe your stepchild, and you go through the process of. So there's other options here. Okay. The individual has not reached normal retirement age as provided in the section, so you're not full retirement, you're still before that. The individual has completed a 5-month waiting period, and that's the one we're at issue with here. All right. Next paragraph. The 5-month waiting period. The waiting period for SSDI benefits consists of 5 consecutive calendar months, beginning with the first full calendar month in which a covered individual satisfies the test of disability. So, bottom line is there's 5 months. They're going to be adjudicating you during that period to see if you meet the 5-step sequential process, which are the disability elements for SSDI. If an individual's disabling condition began before he or she met the insurance requirements, so now we filed here and we're saying, what about if they met it farther back in time before they filed? If an individual's disabling condition began before he or she met the insurance requirements, this is actually different. Began before he or she met the insurance requirements. Okay, so at some point, I know you guys don't all know what this is, but there's this thing called the date last insured. The date last insured. So as you get quarters of coverage, as you work, earn money, pay taxes on it, you get these little quarters of coverage, right? These little coins. And these little coins, you put them on your belts. And as you get older, you get more coins, hopefully if you keep working, etc. If you have enough quarters of coverage for your age, then that means that basically you are covered for this insurance, Social Security disability insurance. That means your date last insured, like it's 2021 right now, could be in 2022. You could be insured to 2023. You could be insured to 2024 because you have enough quarters of coverage, okay? Remember, the 2 elements, and I don't know why they didn't put them in this, the 2 elements you need are, 1, enough quarters of coverage for your age, and 2, that you have 20 quarters of coverage within the past 10 years, unless we're talking about an under 20 individual or an under 30 individual or even sometimes an under 40 individual, because in the rules there's little things here and there that change. When you get above 40, basically everything's consistent. It's just the same, yada yada. It's like, you have this age, you need this many quarters of coverage. You reach this age, you need that many. All right. But when you're younger, you don't have a lot of earnings, and they had to kind of wiggle the system to make it work for younger people. All right, so next thing. If an individual's disabling conditions began before he or she met the insurance requirements. So let's say that you started getting insured because you earned enough money, and now over here is your date last insured, so you're insured from here to here. This is our closed period. Let's say that before you became insured, right? So before you worked and earned enough, over here when you're younger, if an individual's disabling condition began before he or she met the insurance requirements, the waiting period would begin with the first full calendar month after insured status was gained. So let's say that you became insured, your insurance ends, you file over here, or you're claiming basically that your impairment goes back to here. Then that 5-month waiting period starts counting when you become insured. That's what they're saying here. During this waiting period, SSDI benefits cannot be paid, which is what the whole argument is about. Why aren't we paying people who are disabled during this 5 months? And that's the government going, all right, here's what we're going to do. we're going to take 5 months and save money off of their back pay / retroactive benefits, because we're going to basically screw them out of 5 months. That's what it basically comes down to. That's what this is. None of the arguments we've seen so far in this congressional document would hold. They wouldn't hold in 1950. They wouldn't hold nowadays. All right. So during this waiting period, SSDI benefits cannot be paid. It is important to note that this waiting period begins at the onset of the disabling condition and is not affected by the date a worker applies for SSDI benefits. Okay, so that's pretty much self-explanatory. Workers are encouraged by the Social Security Administration, they're putting the thing in again, to apply for benefits at the onset of their disability. No, they're not. They're not. Has the SSA ever reached out to you throughout your life and said, you know what you need to do when you're born? They give you like a little pamphlet as you're sitting there in your little, like, you know, infant thing, and you're like, oh, there's the nurse, and then the SSA is there giving you a little notice. And they could fix this, though. They could do like advertisements. You know, they could do ads. They could do like a YouTube video or something. You know, when you become disabled, you need to file immediately. They could do that, but they don't, because if you don't file for a couple of years, guess what happens? You're outside of your Social Security disability insurance insured period. You're now over here. And if you can't claim far enough back to here, guess what? You got to go on SSI. And that's a lot of money saved to the government. And I know that this video is very pro-claimant. I tend to make very pro-claimant videos because the government, and I make pro-government videos too. I give both sides of the argument. But when it comes to this 5-month waiting period, this is just a scam against the people. That's all it is. It is. You could say, oh, scam's too harsh of a word. Maybe it is, but to me, this is a scam. You know, there's things like Ponzi schemes. That's a scam. We have those too in the government. But this, to me, this is a scam. We should not be taking away months. We should be able to figure out if an impairment is going to last 12 months or not, and not say, well, we got to see how well this person's going to heal. We don't know. You know, hey. Well, if it takes 6 to 8 months at the initial filing level anyways to get an adjudication going on, what are we worried about? Well, in the very beginning, it didn't take that long. Yes and no. Yes and no. People were more spread out then. They really didn't know to file for this, so they go way down the line. It was a different world. I still don't think that argument holds a lot of weight. I don't believe it. As a person who's been with this stuff for a long time now, I don't think so. All right, during this waiting period, all right, so we already did this. The first month counted as part of the waiting period can be no more than 17 months before the month of application, and thus retroactive benefits are limited to 12 months from the date of application. We already went over that. That was in the summary in the very beginning of this. You file. You can go 17 months back claiming this is when your impairment began. Actually, you can sometimes go a little bit farther back. It's called a non-mechanical application, which they should have included in here, but I don't know why they didn't. But the bottom line is you can go 17 months back. 5 of those months don't count. 12 months due for your payments. Boom, you file. You're found disabled. Retroactive benefits. 5-month waiting period that doesn't count or help you in any way. 12 months where you would get benefits. You file. You're found disabled. This, you get benefits called back pay. You're found disabled going forward. These are called forward pay. The disability docket. All right, next page. Retroactive benefits. The SSA provides retroactive SSDI benefits when the onset of disability occurred before an application for benefits was filed. In such cases, the beneficiary is entitled to benefits retroactive to 5 months after the date of disability onset, provided that this day is within 1 year of the date of application. So we've already gone through what retroactive benefits are. Okay, very good. All right, next thing. Here we go. Exception to the 5-month waiting period. Section 223 of the Act provides one exception to the 5-month waiting period. A person who, in the 5 years immediately preceding the onset of current disability, had either received SSDI benefits or had a disabling condition that met the requirements set forth in Section 216 of the Act, is entitled to immediate benefits paid from the onset of disability. So there's no 5 months, right? There's no 5-month waiting period. And here's where the arguments fall apart on behalf of the government. And I'm fair with a lot of this stuff. I give both sides. But here's where the argument falls apart on behalf of the government. If the idea initially, which it wasn't, the whole reason this thing exists, that they promote it to the people, was that, well, it takes the IRS a lot of time to go ahead and calculate your quarters of coverage. We need to figure out if you have enough. You know, we got to wait for the IRS to go ahead and send us the information at the SSA. That was the original reason that the old white hair attorneys told me, you know, that had been practicing literally over 70, 80 years. Okay. And some of them passed away. And of course, the one who just retired is now in his 80s and practiced for almost, I think, 70 years. But the bottom line is this. Is he in his 80s or 90s? I don't know. He's I don't know. I'd have to reach out to him to see how he's doing. I haven't talked to him in a couple of years. Well, has it been that long? Yeah, it's probably been 2 years. All right, so the bottom line is this. I interned at his law firm way back in the day. The bottom line is this. What they were promoting back in the day is, hey, guys, we need this 5-month waiting period because we have to figure out whether or not the IRS, you know, if you have enough quarters of coverage, we need time to calculate things. We need time to figure this thing out. That's what they promoted to the people, which is much better than we, the government, think the American people are a bunch of fibbers who could maybe, you know, not have as severe an impairment as they claim, or maybe they could get better. And we want to see if you can actually go back to work. We're going to like hold your feet to the fire. I know it hurts. I know you're in pain. I know you're struggling, but we're going to see if you can go back to work. Yeah. All right, let's go into this real quick. So what they're saying here is, okay, this is the exception to it. The government claimed, right, that basically we have to worry about these people being, you know, fibbers about how bad they are, or maybe they could actually get better over time, or maybe you know, maybe it's one of those things where they're just doing this to try and get some benefits. You know, we don't know. We don't know exactly what the intent of the person is. So they put in this 5-month waiting rule to essentially try to make sure that we get rid of all those people that, you know, could actually go back to work or try. Okay, that's fine. Well, then why have this one exception? Why have this one exception that if you were disabled within the past 5 years and you became disabled again, why not make them wait another 5 months? They could be fibbers again. They could potentially be able to go back to work, right? They could be a double fibber. Think about that. They created an exception that said, well, we got it from you once, we're not going to get it from you again. You know? Well, what does that really say? That says, just to make it simple, that, hey, we took something from you that was a cost. Maybe we should have taken it, maybe we shouldn't have. But we're not going to get you with it the second time. We're not going to snooker you another time. That's what this essentially is saying. Exception to the 5-month waiting. Section 223 of the Act provides one exception to the 5-month waiting period. A person who, in the 5 years immediately preceding the onset of a current disability, had either received Ssdi benefits or had a disabling condition that met the requirements set forth in Section 216 of the Act, 42 U.S.C. 416, is entitled to immediate benefits paid from the onset of disability. So they're saying, we're going to get you once, but if you become disabled again, and it's within a 5-year period, we're not going to get you again. So let's just break that down, the logic. We're going to take things from you that we probably shouldn't have taken from you to begin with, but we're not going to do it again because it might be unethical at that point. But it is ethical to us as the government if it's past 5 years. And here's the reasoning for that. If they put you through a CDR and kick you off of benefits and then you get back onto benefits, they're saying, you know, we reviewed you, we may have made a screw up, whoops, and now, you know, and now it looks like you actually were disabled under our rules and regulations, so we're not going to hit you with that 5-month waiting rule. We're not going to do it. Nah, we're not going to do it a second time. Because we like you, the American people, so said the government. So you see how much, you know, I don't want to say bullshittery, but you see how much, like, why would they create the rule and then not apply it to you with this one exception of a 5-month wait, of a 5-year, you know, grace period? Like, why even have the grace period? Why not just keep hitting the people again if you ethically and morally feel that this rule is correct? If you feel that they should have to wait? If you feel that it takes that much time for the IRS to figure out how many quarters of coverage you have. If you feel it takes that much time to see if the person's a faker. Is this enough to say, well, we don't think the person's a faker this time anymore because, you know, they might have they were found disabled before, so now we know they probably are not a faker. And you could use whatever word. You could remove faker and say somebody who is just being disingenuous with their own abilities to go get a job. You could put it in fancy legal terminology, you know. All right, legislative history of the SSDI waiting period. Oh, this should be good. This is the history of where this comes from. A waiting period from the onset of disability to eligibility for benefits has been part of the SSDI program from its inception in 1954. Remember we were talking about the 50s, cool cars, the cars had fins, milkshakes, you know, pizza shops, stuff like that. Hey, it's the 1950s. In 1954, Congress made the first provisions for loss of work due to disability and included language that exempted a period of disability from being counted when determining retirement benefits. So what they're saying here is in 1954, they created this stuff, and the stuff about whether or not you can work, right? That's the whole shindig here. Okay, then, 1954. And then, don't miss this. This is important. And included language that exempted a period of disability from being counted when determining retirement benefits. So they had a waiting period, like our good friend, the 5-month waiting period. 2 years later, so they realized, 2 years later, Congress authorized the payment of SSDI benefits to persons over the age of 50 after a 6-month waiting period. Oh, now we got a 6-month waiting period, and it's got to be after 5. Okay, cool. So we're starting to shape this program. So right now, in 1954 we created it. 1956 we amended it because we got to play with it, right? We got to get this thing right. We're gonna take our 6 months now, right? That's what they're saying here. They're saying 1956. They said, hey, we had a waiting period. Why don't we push it to 6 years? We could get 6 years and not having to pay these American citizens. That could be even better. All right, and it continues. The age requirement was removed in 1960, so you didn't have to just be 50 years old and then to become disabled and continue with disability benefits. The age requirement was lifted, and you were just stuck with the quarters of coverage work requirement. Okay, so they got rid of this whole you have to be 50 years old or older, because let's call it like it is, if somebody young becomes disabled, how stupid is it that we don't go ahead and pay them? Okay. So they were figuring it out. 1954, they came out with a law that in general was a good idea. 1956, they figured out a way to screw over more American people. And then basically in 1960, they started to open it to people who were younger. All right, we still have a 6-month waiting year period in there, but let's go through this. Congress's justification for instituting a waiting period. This is the good part. This is where we learn about the how the heck did you come up with that one? You know, and my father used to always say to me, oh God, what was this phrase? It was, well, why didn't you think of that? Well, why didn't you do that? You know, one of those gigs. And then I learned, it took until I was about 12 years old, that the correct answer was, because I'm an idiot. I missed it. I'm sorry. Hey, you know, you would try to justify it when you were younger. Oh, I was trying, hey, no. The correct answer is I was an idiot. We're going to go into their justification now. Here we go. 1955, the House Ways and Means Committee recommended passage of the proposed Social Security amendments and discussed the rationale for a 6-month waiting period. Now, we're not talking about 5 months here. We're talking about 6 months here. They're really getting deep in the pocket of the American people now. We're taking a whole extra month. A committee report cited the unique nature of the federal definition of disability. Yeah, it's detailed as all heckaroo. And called its requirement that a disabling condition be expected to result in either death, be terminal, or long duration, 12 months or more, more exacting than the disability definition commonly used by commercial insurance carriers at the time. That's why when your insurance company is like, you're disabled, the SSA is like, not even close. You are not even close. Our standard, way worse, way harder to get onto disability benefits. That's why when people are like, well, my insurance company found me disabled, and I have to sit there and go, well, guess what, buddy? All right, now here it comes. Blah, blah, blah. Commonly used by commercial insurance carriers at the time, many of which had their own 6-month waiting periods. In addition, the Ways and Means Committee expressed that the 6 month. Now, let's go back to that real quick. The disabling condition be expected to result in either death or long duration, more exacting than the disability definition commonly used by commercial insurance carriers. So we based our disability program off of commercial insurance carriers, and then we made it much harder for them to get on disability benefits through the federal government, because the federal government is there for you in your time of need when you become disabled. Except the thing is, they're going to make the definition of it really, 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 really severe, even more severe than the companies you have to pay through your insurance to basically have a lifeline that they then quote as being the support you will use while you're waiting to be found disabled. This is probably one of the more unethical thought logic extensions you'll ever see in the government when it comes to Social Security benefits. They're presenting the idea, let's get to the part that's even the worst, used by commercial insurance carriers at the time. Many of these commercial insurance carriers, many of which had their own 6-month waiting periods. So the government was like, hey, here's what we're going to do. You're going to like this. The American people won't, but here's what we're going to do. These insurance carriers, we are going to base our system off of them. We're going to make our definitions severely or more difficult to get on the benefits, more severe in the impairments definitions to be able to get onto the USA's disability program. Even more difficult than the very difficult insurance carriers, right? Now, they use this whole 6-month waiting period. And we're going to take that. We're going to copy that. But then, as we read earlier, LTD, STD benefits, we're then going to allow, we're then going to promote the idea that, because this person has a waiting period through our program, there's other programs out there that they can go ahead and get on during that waiting period. Even though we, the federal government, are taking the waiting period from those commercial insurance groups. And what we're going to do is we're going to tell the American people that those commercial insurance groups, boy, they can go on them first, and then if they meet the really severe requirements of our program, go on to our federal disability program. How do you even sell that to the American people? And they're still doing it today. But how do you sell that to the American people and not end up getting put out of office? And the way you do it is you just make the mega government seem so big that you just can't do anything about it. The federal government makes a lot of people feel like they're alone because it's so massive, and having to interact with them is just so difficult. And that's how they do it. That's how they basically sell this idea that they can do these things, even though you paid for them. All right. In addition, the Ways and Means Committee expressed that the 6-month, so it's the committee that's overviewing it back then, 1960s area, waiting period, well, it was actually before that because that's when they put the 6-month waiting period, 1956, that's when they put the 6-month waiting period details into motion. Waiting period was long enough to permit most temporary conditions to be corrected or to show definite signs of probable recovery, and would be of sufficient length to make it unprofitable for a person who can work not to do so. Let me read it again. Waiting period, 6-month waiting period, was long enough to permit most temporary conditions to be corrected. Okay, so the idea is you've got an impairment. You're filing for disability benefits. They're saying 5 months is a long enough period for basically your impairment to magically heal through your immune system or have surgery to correct it. Now, granted, back then they didn't know, because medication, medical treatments, surgeries, they're not what they are nowadays. Nowadays, things can get fixed really easily. But back then, they still had potions, okay? So, yes, this makes a little sense. Long enough to permit most temporary conditions to be corrected. You would think that even still then they would have an idea as to what temporary conditions were, like, I've got a rash and it's going to go away. Or, I've got a knee problem and I have surgery and, hey, life is good. But the reality is, that's an okay argument. Okay, maybe, but let's get to the next one. Or to show definite signs of probable recovery. They put probably recovery. Or to show definite signs of probable recovery. So, keep in mind, they send you to a CEME, Consultative Examination Medical Appointment, where they send you to their doctor, the SSA's doctor. And the idea is that their doctor tends to be obviously very pro-SSA, very anti-claimant. And what they do is they utilize this to go ahead and say, well, it looks like the person's not that bad. Our doctor said so. He's a specialist, even though he only works for the Social Security Administration, has only worked for the Social Security Administration for the past 10 years, and only does Social Security Administration-based reviews, medical reviews on claimants, even though he's that person. Even though he would not be able to afford his mortgage, his business, the car that he drives without the SSA, even though all these factors... we're going to go with the opinion of this doctor that basically there's improvement from what your doctor is saying, which is that you are getting worse or staying the same. But if their doctor says, hey, a little bit of improvement, improvement. So what you've got here is, let's go back to it, or to show definite signs of probable recovery. So the first argument was long enough to permit most temporary conditions to be corrected. So the impairment is fixed. Argument 2, show definite signs of probable recovery. So 1, it's fixed. 2, it's getting better. Or 3, and this is the bad one, the unethical one, and would be of sufficient length to make it unprofitable for a person who can work not to do so. This is where they're basically saying the American people are fibbers, that they're going to apply, and if we make them wait 5 months, it's not profitable for them to not work during that 5-month period because they're still going to have to pay for stuff. Ergo, it'll force them to go back to work. Yeah. That's not good. That's a bad reasoning. Now, granted, back then they didn't have the medical knowledge that we do now. They didn't have the x-rays, MRIs, clarity. They didn't have the different fixes that we have in the medical industry. But still, what they're saying here is these people in the 1950s, boy, are they fibbers. They could go ahead and apply for this program because we've told them about it so many times and told them to apply the moment they become severe. They could be trying to make money on a monthly basis from this program by not working for a couple of months and applying. They could be doing that. Now, are there fibbers? Yeah. Are there fibbers nowadays? Of course. Of course. But the program's really hard to get onto nowadays. Back in the day, it wasn't. So the bottom line is, this made more sense back in the day because the system was much easier to get onto. But it's still calling the American people fibbers. And it should not have to call them fibbers. It should have to basically have a system in place where there's not a waiting period, but rather checks and balances that are not taking money from the American people, rather checks and balances that medically know whether or not this is an impairment that will last a longer period. Another thing that they do, which is hugely unethical, and they do it on a daily basis, is that if somebody gets into a car accident, they'll put that claim off, even if it's SSI. They'll put that claim off for 4 months, 5 months, 6 months to see if there's improvement. Think about that for a moment. They'll put the claim off for 4 or 5 months to see if there's improvement. The person has no money, they were in a car accident, they're going to lose their home, and they put the claim off for 4 or 5 months until they can figure out if there's improvement. Another hugely unethical thing that needs to be illegal. That to me is criminal behavior on behalf of the SSA. That needs to be made illegal. Next one, changes to the SSDI waiting period. 2 significant changes to the original 6-month waiting period have been passed as part of the creation of the SSDI program. The first change eliminated the waiting period for disabled workers who were previous SSDI recipients, or the first change eliminated the waiting period for disabled workers who were previous SSDI recipients or who had a previous disabling condition in the 5 years prior to the onset of their current disability. So what they're saying here is, the first change, they eliminated the waiting period for disabled workers who were previous SSDI recipients or who had a previous disabling condition in the 5 years prior to the onset of their current disability. To be exempted from the waiting period, the previous disabling condition must have met the statutory definition of disability as provided in Title II of the Act. So what they're saying is they got rid of the 5-year part. Okay? In their reports to the House and Senate on the 1960 amendments, the Ways and Means Committee The Ways and Means and Finance Committees affirmed that the 6-month waiting period for those with previous disabilities is a possible barrier to return to work efforts, stating that most disability insurance beneficiaries who return to work do so despite severe impairments. That's the argument we've been making. And this is what the Ways and Means Committee was fighting for the American people here. Most disability insurance beneficiaries who return to work do so despite severe impairments. So they, instead of they're fibbing, what they're saying here is the American person gets injured. They're severely injured. They're severely disabled, and they still go back to work because they need money. Where a disabled person becomes employed without any improvement of his condition, a more or less slight change in his situation can result in the loss of his job and make him once again eligible for disability insurance benefits. So what they're saying here is this. He gets injured. He can't work. He's severely injured. He's severely disabled. He goes back to work anyways. He can't do the job after 2 months. They fire him. Back to disability benefits. Other disabled persons whose medical conditions may improve sufficiently to require termination of benefits may subsequently grow worse again and become re-entitled to benefits. He was injured. He went back to work. He couldn't work. It made him worse because he pushed himself. Okay? And then in this one, other disabled persons whose medical conditions may improve sufficiently to require termination of benefits may subsequently grow worse, right? So he got worse over time again. They took the benefits away. They got worse over time. They gave it back, okay? A new 6-month qualifying period during which they receive neither earnings nor benefits imposes a hardship on them and their families and may be a real bar to any further work attempts. So they're saying, they're breaking it up into arguments. They're saying the 6-month rule being applied a second time, taking money a second time. Okay, so a 6-month qualifying period during which they receive neither earnings nor benefits. So there's a 6-month period where this is the second 6-month period, not the first one, the second one, right? So they got found disabled, they took the benefits away, they reapplied, they're found disabled. For that second application, there's no 6-month waiting period. So here's why. A new 6-month qualifying period during which they receive neither earnings nor benefits imposes a hardship. Yeah, if you got a 6-month waiting period where you were disabled before, they took it away, you're found disabled again, you're taking away literally that person's rent, that person's mortgage, that person's car payment for 6 months. It imposes a hardship on them and their families, right? Because they may have been the breadwinner. And may be a real bar to any further work attempts. So let's say this person could do a part-time gig, do a little bit of work and things like that. Well, if you just made this person homeless, you just took him from maybe being able to do part-time work into the category of homeless living under a bridge. The second change to Ssdi waiting period reduced the waiting period from 6 to 5 months. So, okay, let's go through rule number 1 that changed. They got rid of the whole 5-month waiting period thing. They said that, okay, you don't have to wait 5 months. It doesn't have to be within the 5 months for us to, not have to take another 6-month waiting period. So they're saying, okay, it doesn't have to be within 5 years, right? So let's say you file, let's say you're found disabled, and then boop, you lose your benefits, and then within 5 years you're found disabled again. They're getting rid of this 5-year period thing, where basically they can take, only 6. I'm doing a terrible job explaining this part. Let me explain it. You're found disabled. They remove your benefits. You're found disabled again. They used to be able to take another 6 months out of your second application and being found disabled, so long as they were within you being disabled and you being found disabled again within a 5-year period. Now they got rid of the 5-year period in total. So you could be found disabled and then 20 years from now be found disabled again for SSDI benefits, and there's no 5-year waiting period. Okay? Or that there's no period in which you have to be within 5 years for them not to take another 6 months off of your benefits. So let's do it under the new rule. You're found disabled, life is good, you lose your benefits, so we go 1 month back. We're in the you were disabled part. You're found disabled again 20 years later. They're not allowed to take another 6 months worth of back pay out of your benefits. And if it's the modern day, they're not allowed to take another 5 months out, right? So there's no more 5-month waiting period on the second winning of benefits. Hopefully that clarified it. The second change to SSDI waiting period reduced the waiting period from 6 to 5 months. The intent of this change was to reduce the financial burden on applicants, and the Ways and Means Committee reported that reducing the waiting period from 6 months to 5 months would diminish the financial hardships faced by those workers who have little or no savings or other resources to fall back on during the early months of long-term disability. Okay, so the second Senate Finance Committee, all right, so now we're away from the Ways and Means Committee, now we're talking about the Senate Finance Committee, went further than the House and recommended reducing the waiting period to 4 months. So we know the intent of the government started to shift. It started to shift away from this being a great idea to take from the greedy insurance companies and their 6-month waiting period. And it started to become, well, maybe we shouldn't hit them every time that they apply and get found disabled. Maybe we should reduce it to 5 months. Maybe we should reduce it to 4 months. The House screwed over the people. The Senate pushed to help them. Usually, those roles tend to be flipped. Usually, it's the House that wants to push for more for the people, more money to the people. And the Senate says, wait a minute, hey. So this is interesting. This is important. I had to stop the video before because I had people that were actually coming into the House. But either way, we're going to keep rolling. Potential income supports during the 5-month waiting period. Now, and the mic's on yet. Let's talk about this. The next argument is horrifically bad. Absolutely horrifically bad. Let's enjoy it. Supplemental security income. Title 16 of the Act authorizes supplemental security income benefits for individuals who meet the statutory test of disability or are over the age of 65 and who fall below specific income and asset thresholds. SSI beneficiaries need to have any prior work history. Need not have any prior work history or meet the insurance requirements of SSDI. So SSI people are disabled people. If they're under that 65 rule, they're people who have worked very little or have not worked at all. Okay. SSI beneficiaries need not have any prior work history or meet the insurance requirements of SSDI, and there is no waiting period between the onset of disability and eligibility for SSI benefits. So what they're saying here is, hey guys, so SSDI only has a 5-month waiting period. SSI has no waiting period. So you could go on SSI if you're poor and then transition over to SSDI. A terrible, terrible, terrible argument. Here's why. Most claims for SSI benefits and SSDI benefits, most approvals occur at the exact same time. Why is that? Because when you file for SSI and SSDI, they have to go through the same severity requirements medically to see if you meet the element 3 listing level requirements for severity, and if not, the same work requirements of element 4 and 5, the 5-step sequential process, to go onto either program. So the same 5-step sequential process applies to SSI and SSDI, which means that when you apply for both, you don't more quickly get on SSI. You're adjudicated for both at the same time. So what they're selling here is, hey, we got this poor person's disability program. You could go on that first because there's no waiting period. Pretty good idea, right? Yeah, that'd be a great idea if they had a separate division that adjudicated SSI claims really fast. They don't. They all go to the same person at DDS, Disability Determination Services. So this is a terrible argument. Oh, everything's going to be fine because we got this other program. You can't use that other program for this. They're both adjudicated at the same time by the same adjudicator. So this is a terrible argument. You can't get on this faster in that sense. You just can't. All SSI beneficiaries, regardless of disability or state of residence, receive the standard benefit of $710. Well, it's different now for an individual living independently, or $1,066 for a couple living independently in 2013. 44 states and the District of Columbia add a supplement to this benefit for their residents. The amount of the federal benefit plus any state supplement may be reduced or offset by some earned or unearned income. 39 states, the District of Columbia, and the Commonwealth of the Northern Mariana Islands grant Medicaid eligibility to all SSI recipients or have Medicaid eligibility rules that are the same as those of the SSI program. All right, all they're saying there is some states offer a little more money on top of the federal benefits. Some states offer Medicaid. Florida's one of them, where when you're found disabled, you automatically get Medicaid. All right, so let's go to the next argument. So we know that the SSI argument is terrible. What they're arguing here is that, hey, there's no 5-month waiting period for SSI. You just go on that and then go on SSDI. That's horrible. If you're truly severely impaired, guess what? Your SSI claim and SSDI claim, when concurrently filed, go to the same filing office, which then goes to the same DDS adjudicator, Disability Determination Services Group, and they decide your claims at the same time. So to say you're going to be found disabled for one before the other, almost impossible, because the same adjudicator is adjudicating both. They send them up for quality control review to the same group. So they're very unlikely to send, and it would be hugely inefficient for them to send one and then send the other. They don't do that. So we know that argument is totally useless. So I don't blame this guy right here for making useless arguments. The government's been using these useless arguments for literally decades. And the funny thing is we're about 30 years away from it being a century. Okay. Next one. Temporary disability insurance. California, Hawaii, New Jersey, New York, Puerto Rico, and Rhode Island. So that's 1, 2, 3, 4, 5 states. It's only 5 states. Why are they even making this argument? But 5 states currently administer temporary disability insurance, TDI programs, that provide either state or private benefits to workers with disabilities who are not receiving SSDI benefits. In addition, the employees of the railroad industry in all states are eligible for TDI. So everything's going to be okay because these 5 states have got a fix. This fix should be applied throughout the United States. And then that argument, their 5-state argument, albeit not strong. Now they're going to bolster it and say, by the way, if you, sir, were in the railroad industry, because so many people are in that industry nowadays, the 50s there were, I guess, more, but now we have so many more people, you know. But either way, let's go back to it. In addition, employees of the railroad industry in all states are eligible for TDI benefits administered by the Federal Railroad Retirement Board in accordance with provisions of the Railroad Unemployment Insurance Act. So the railroad industry was able to negotiate better benefits for its employees, and that's at federal level. But everybody else, other than 5 states, gets screwed. That's basically what they're doing here. But from their standpoint, they're arguing, guess what, guys? 5 states put it in place because they wanted to help people. They realized that there was a problem. Oh, and the railroad industry negotiated with us in the beginning back in the day, and those people get it too. So you should be thankful. You should be super duper excited, exuberant, astonishingly happy that these things are available to you. Unless you're not in the railroad industry or living in any one of those 5 states like all the other states in America. So you can't even make 1/3 of the states. You can't even make a 1/4 of the states argument. That's 5 states. 5 states is what they're hanging their hat on. All right. In addition, employees of the blah 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 blah. Okay. Okay. So the 7 TDI programs provide temporary benefits with maximum durations of between 26 and 52 weeks for those with an earnings history who are unable to work because of a disability and who are not receiving workers' compensation for SSDI benefits. Workers' compensation. Workers' compensation systems in each state provide wage replacement and medical benefits to workers unable to work because of an employment-related illness or injury. All right, so we're talking about workers' comp. Workers' compensation. Most people know it as workers' comp. You got injured on the job, okay? And now they're going to use this argument as this is what you get in between going on SSDI, and therefore a 5-month waiting period is super kosh. It's super cool. And Shadow's growling under the... Yep, that's him. Come here. What's wrong now? You unhappy? Not enough treats? You're always getting treats. All right. All right, let's go through this. All right, workers' compensation. Workers' compensation systems in each state provide wage replacement and medical benefits to workers unable to work because of an employment-related illness or injury and may be able to pay benefits during the Ssdi waiting period. Okay, so if you get injured at work, your long-term disability benefit, or rather your workers' comp may be able to jump in. Okay, the federal government administers workers' comp for its employees under the Federal Employees Compensation Act. So yeah, I mean, you know they're going to cover their own employees. They got a bunch of programs for them. The federal government also administers workers' compensation systems for some private sector employees in the maritime, mining, and railroad industries through the Longshore and Harbor Workers' Compensation Program. Yeah, because bottom line is they negotiated back in the day. And there's more. Maritime, mining, and railroad industries through the Longshore and Harbor Workers' Compensation Program, the Black Lung Benefit Program, and the Energy Employees Occupational Illness Compensation Program. So basically, if there were toxic tort situations in the history of America, like getting black lung, or having some maritime issue, or having some, issue with the railroad stuff, and they negotiated way back in the day for the federal government to cover them, then yeah, if you're in those industries, cool, you can access that. But in most instances, workers' comp will cover you if you get injured on the job. If you get injured on the job. If you don't get injured on the job, then you're going to have to rely basically for immediate benefits in the form of your short-term disability or your long-term disability options. Okay. Unemployment compensation. In each state, workers covered by state unemployment insurance systems may be eligible to receive partial wage replacement in the event of a job separation. In Florida, we call it reemployment because we're cool. But it's really usually called unemployment. And that's what we're talking about here. You lost your job, you need benefits, that's unemployment. Okay? So let's take a look at this. The states, however, require that those receiving unemployment compensation be able and willing to work, which a lot of the SSA judges used to use to go ahead and say that you're not disabled. So it's a catch-22. Here's what they would do. You would, be disabled enough to not work. You would then sign a document that said, hey, guess what? I'm going to take these unemployment benefits because I need money. And on that unemployment document, it said, hey, guess what? I'm ready and willing to work because if I don't sign this, I'm not going to be able to eat. So what do people do? They sign it. And then what happened? And I had one of these 2 weeks ago. The administrative law judge brought it up, and I was disgusted by it, and I went after him. Which is never a good deal, because here's the problem. There's no opposing counsel in disability law. When you go to a hearing, right, at the very beginnings of this whole thing, when you go to a hearing, so initial filing, get denial, reconsideration, get a denial. ALJ hearing level, right? You go in front of a judge for a hearing, but it's more like a trial. You have to present all your evidence, have testimony. You get a denial, you go to appeals counsel, and you're supposed to only use the evidence from that. It's more like a trial. The reality is there's no opposing counsel. The judge isn't a neutral person. The judge is there asking questions as essentially the opposing counsel. That needs to be fixed too. All right, but let's go back to this. We're still working on the 5-month waiting period. Okay, so here we go back to this. The states, however, require that those receiving unemployment compensation be able and willing to work. And the judges at the ALJ hearing level will say, oh, well, you signed that you're able and willing to work. But see, there's a counter thing to this. If you are able and willing to work, that doesn't mean that you can work full-time. You could be only able to work partial part-time or full part-time, which is not full-time. A day over or an hour over part-time gets you into your full-time. But if you're not able to work that extra hour over, you're only working part-time. Now, a lot of the judges, if they see part-time work, they're still going to deny you because why not just work that extra couple of hours to put you into full-time, and then we don't have to pay you as the federal government. Are you starting to see how this was not made with the best interests of the people in mind? Are you starting to see the problems that are eroding the people's rights here? Let's go back to it. The states, however, require that those receiving unemployment compensation be able and willing to work, a condition that may exclude many waiting for Ssdi eligibility, especially an individual who would earn in excess of the substantial gainful activity, since it is assumed that the individual is unable to work. Unemployment benefits are administered by the states within federal guidelines under Title III of the Act, and unemployment compensation provisions for individuals who are ill or disabled vary by state. Fine. Private disability insurance. Now we're talking about the groups that they originally modeled Ssdi after. Okay, that was back in 1954 that they were looking at that and copy and pasting the rules and regulations that the private industry created. Private disability insurance programs offered by employers can be used to provide wage replacement benefits during the 5-month waiting period for Ssdi benefits. So you're going to have to pay for this. Just remember, before you became disabled, you're going to be paying for this, then you become disabled, and then you're going to try and use this and then transfer from this over to federal benefits. All right, so let's go through it. In March 2010, 38% of the private sector workers participated in some form of short-term disability insurance plan, while 32% of private sector workers were covered by the long-term disability insurance program. It has been estimated that up to 20% of Ssdi beneficiaries have received payments from private disability insurance policies before being eligible for federal benefits. This is an awesome argument for those who were working, and non-existent as an argument for those who have to go on SSI. Is this a good argument? Should people have to pay a private group to cover them during a 5-month waiting period? Well, even if we got rid of the 5-month waiting period, you'd still have to wait forever for them to adjudicate the claim. You would just get paid more back pay and retroactive benefits. So you're still going to need private disability insurance. That's the reality of it. But should you have to need it? Well, no. You pay a bunch of taxes to have this other insurance. But wait. Let's say I go into short-term disability benefits. Let's say I go to long-term disability benefits, and then a year and a half down the line, they find me disabled. I mean, I get to keep that money, and then I get to keep my back pay, right? And my retroactive benefits. The federal government's going to pay me for all that time minus the 5-month waiting period for all that back pay and retroactive benefits, right? And I get to keep it all. I get to keep what they gave me from my insurance company. I get to keep what the government gave me too, right? And no. Here's some more, you could call it bullshittery, or you could call it screwing over the American people. Here's how it works. The way it works is, when you get paid back pay for those months that they were paying you for long-term disability benefits, or rather long-term, LTD benefits, long-term disability insurance benefits, they're allowed to, as part of the contract that you sign when you sign up to pay for this insurance, they're allowed to take those back pay funds to pay for those months that you were receiving the insurance that you paid for originally to have. Let me run you through this one again. This is a high level of screw the American people over. Are you ready? Injury happens, can't work. You're on LTD benefits or STD benefits. You're in the transition of doing this stuff, right? Usually it's you go on short term, then you go on long term. All right. Then you're found disabled way over here. You're riding long-term disability benefits during this period, right? For each month that you were waiting, to be found disabled, you would normally get back pay benefits, maybe even retroactive benefits, right? But let's make it simple, just for the purposes of this. You'd get back pay benefits. You get paid for each month in which you were disabled from your protective filing date / well, in this case, it would be actually your alleged onset date. So let's say they approved it from the alleged onset date. That was during when they were paying you these long-term disability benefits. So you're getting a check for long-term disability benefits. You're found disabled. And like normally you'd think like, hey, I get to keep that money and then I get to keep my back pay benefits. They're stackable, right? I got to use those for when I was struggling. And then I get to use this other fund as like seed money to kind of get my life back on track. No. That's not how they do it. The way they do it is, for each month that you receive benefits that the long-term disability insurance provider was paying you. So if you get back pay on this month and you had LTD benefits on this month, then the LTD carrier takes your back pay and counts it against what they paid you for your long-term disability benefits for that month. Now, normally when you have insurance, Insurance is for when something goes wrong and they pay you money, but they don't usually come back for it. In this case, they do. And if this sounds illegal to you, it probably should be. It probably should be. Yeah. Think about that. The insurance company, which you hire to take care of you when something bad happens, is covering you basically until you're found disabled for federal benefits. And then they look at whether or not you get back pay and take the back pay for each month that you were receiving when they were paying. Some are even worse. Some give you a bill of what they were paying and they say, well, we have to take this extra. Some even play that game. So if this feels almost criminal in activity, it pretty much is, in my opinion. What it should be is the long-term disability carrier pays you until you're found disabled, and then you get to keep your federal disability benefits of back pay and not have to pay it back to the long-term disability insurance carrier. Remember the groups that they originally based this whole system on. Okay? All right. So, bottom line is this. Let's keep rolling through this. We're kind of getting to the end. Private disability insurance. Private disability insurance programs offered by employers can be used to provide wage replacement benefits during the 5-month waiting period for Ssdi benefits. So once again, private disability insurance programs offered by the employers can be used to provide. So we're talking about additional insurance carriers that are private. Okay. We just went through that section. Impact of the 5-month Ssdi waiting period. The 5-month waiting period between the onset of disability eligibility for Ssdi may have a negative impact on the income of those seeking to enter the program. Yeah, no kidding. During this waiting period, persons with disabilities are either not working or earning less than the substantial gainful activity threshold. In addition, claimants are either not receiving monthly benefits to replace lost wages or receiving only SSI benefits. We already threw out the whole SSI benefit argument. It's just not going to happen. They're making an argument here that literally does not happen. Replace lost wages, okay, which are usually lower than the SSDI benefit. Yeah. Okay. A July 2012 analysis by the Congressional Budget Office estimated that the elimination of the 5-month waiting period would increase outlays to SSDI by approximately $8 billion in 2022, about 4% of the program's outlay. So what does this all come down to? They're saying, I'll read it again, it's all about money. That's what this really comes down to. A July 2012 analysis by the Congressional Budget Office, so a long time ago, almost a decade ago, estimated that the elimination of the 5-month waiting period would increase the outlays, increase how much the government has to pay its citizens who are disabled. Just a disabled person. That's the person we're trying to take money from here. That's the person we're screwing out 5 months here. A disabled American. Okay? A July 2012 analysis blah, 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 would increase outlays to the SSDI by approximately $8 billion in 2022, about 4% of program outlays. It's all about money. That's why it's pretty much almost the last sentence that they bring up here while trying to defend. So an article is a problem when the entire article is about basically the reasons it's okay. There's other programs that will cover this. And now we know most of them don't really work that way, or they get the money back and you get, all that stuff. But then you get to the last page, right? You get to the last page. There's a problem when the last page says, almost the very end of it, 5-month waiting period would increase outlays, would cost the SSDI program approximately $8 billion in 2022, about 4% of the program outlays. So they spend the entire document defending it. Sure, they throw in a few little bones of, well, the Senate would like to see it at 4 months, and the House, well, they're keeping it 5 months. They throw in a few bones as to, well, it's really screwing over the American worker. They throw in a few of those. But at the very end, there's a problem when the last paragraph, realistically, not just the little conclusion paragraph, but the last real paragraph it states, well, it's going to cost us a lot of money. It's going to cost us another $8 billion by 2022. Now, we know that's actually a low number. It's going to cost more than that now. Last and final paragraph. This is the summary paragraph. One impact that may not be as clear, however, is the role that the waiting period plays in discouraging possible beneficiaries from applying for benefits. So wait a minute. What we're saying here is One impact that may not be as clear, so they're not sure how this is going to affect things, is the role that the waiting period plays in discouraging possible beneficiaries from applying for benefits. Didn't you just base this entire paper, this entire document, on the idea? There were 3 arguments, and that was number 3, that there are people that they are trying to discourage from applying. And that's why they put this, at that time, 6-month waiting period in place. Remember? Americans could be fibbers. That's what they were putting in there in the 1950s. Americans could be fibbers. We don't want to just get this. And then wasn't it the entire purpose and point that this was trying to promote? That the SSA always and continuously, ongoing, will always continue to do this. Tell the American people that at the onset of their disability, they need to apply immediately. Which we now know is total, come on. We know that that's not correct. How many times has the SSA reached out to you and said, hey, look, by the way, I know you're not feeling well, I know things happen, but if it ever gets really bad, we don't want you to be a fibber here, but if it ever gets really, really bad, we want you to apply immediately. Has the I want you to ask yourself this. If they, and as this stated, and as they pushed, they just keep, have they ever told you to apply for disability benefits? Ever? In the history of your existence, 365 days a year, all those years combined, have they ever told you to apply for disability benefits? Once. Twice. 3 times. 4 times. I can't think of many people who would make it to 2 times. I can't think of it. Some of you who read the website, when they sign up for their account, might be like, yeah, they notified me then. But I know a lot of you didn't read that stuff, So let's go back to this. One impact that may not be as clear, however, is the role that the waiting period plays in discouraging possible beneficiaries from applying for benefits. So they're not sure what role that will play, even though they based the past 70-ish years on that argument. They're not sure what's going to happen with it, even though they spent the past 70 years, almost 70 years, basing this program on that, the whole waiting period. Sounds like government logic to me. Hey, this waiting period and its accompanying loss of income lessen the overall generosity of the Ssdi benefit. And think that's the last sentence. That's the last sentence of this entire report. This waiting period, the 5-month waiting period, and its accompanying loss of income and the thousands of dollars you lose because of it. Because think about it. Let's say that the average person gets $1,200, per month. And it could be more, it could be less. But let's get out our quick calculator so that we can do a couple of these really quickly. Sorry, my Mac Pro is waking up. And the big Mac Pros, the 12 cores, they take like 3 minutes to wake up. Literally clicking on calculator. All right, we're going to go to the iPhone. Okay, so let's say that somebody makes $1,200 per month on Ssdi. Let's multiply that by 5. That is $6,000 that they are costing you of benefits that which you should have received. Let's say that somebody is earning less than the national average at around $1,000. That's $6,000, or sorry, that's $5,000. Let's say that somebody's earning around $800 times 5. That's $4,000. Back to $1,200 times 5, that's $6,000. Back to $1,500 times 5, that's $7,500. $1,800 times 5, that's $9,000. That's a lot of money. That's a lot of money that they are taking from you. And the final statement of this paper, what they use to give to senators, things like that, to advise them of what the program is. Well, after everything we've gone over, this waiting period and its accompanying loss of income, and its accompanying loss of income to the American people, right? Lessen the overall generosity of the Ssdi benefit. What's a problem is that you already paid for those 5 months. You did. You already paid for them. And they're taking them away. Should this rule be gone? Absolutely. Let's talk about other things here. So September 24th, 2019. Brown introduces bill to eliminate the waiting period for Social Security disability benefits. In 2017, more than 10,000 Americans died while waiting. Okay, so what he's saying there is people who applied were so severe that they died. They were terminal and quickly to become terminal during that 5-month waiting period. So they didn't get any benefits. You know that big screen TV they wanted to buy while they were dying, while they were passing away? Ain't going to happen. Okay? All right, Washington, D.C. today, U.S. Senator Sherrod Brown, Democrat, Ohio, joined with his colleague Senator Cassie, Democrat, PA, to introduce the Stop the Wait Act. Cool, let's read about it. After waiting months to qualify for coverage through Social Security disability insurance, individuals with disabilities are forced to wait another 5 months to get a disability check and another 2 years to obtain health coverage through Medicare. We'll go through the whole 24-month Medicare thing, too. I'm doing another video on that, which is the just absolute, I mean, there's not a word for how stupid that law is. The Stop the Wait Act would eliminate these outdated mandatory waiting periods imposed on individuals with disabilities that can potentially further harm their health by delaying critical health care. Delaying critical health care. Like the stuff they would need. Like getting money to basically get great health insurance to get that surgery you need to not die. Okay, Social Security, and a quote, Social Security disability insurance is a lifeline for individuals who can't work because of a disability, said Senator Brown. This legislation eliminates unnecessary red tape that leads to gaps in disability insurance and healthcare coverage and ensures Americans don't lose access to the benefits they have earned. All accurate, all true. Cool. Senator Brown, that's good. Good job. Excellent. In 2017, more than 10,000 Americans died while waiting for the SSDI benefit to begin. The wait times greatly affect adults with rapidly progressing diseases such as Huntington's disease, cancer, cystic fibrosis, and other serious conditions. Yep, we know that. American workers who have developed a disability may be eligible for Social Security disability insurance, a benefit financed by employee-employer payroll taxes. Remember how I said you paid for those 5 months? Even though they're taking them from you? You paid for them. You already paid for them. You're due them. SSDI requires an application and determination period that can last more than 18 months, as well as mandated 5 months to obtain a disability payment and then an additional mandated 24 months to receive Medicare benefits. The Stop the Wait Act aims to remove these unnecessary and onerous requirements by, here we go, requiring the Social Security Administration to begin payment to an individual who is eligible for SSDI immediately. You already paid for them. You should get them immediately after they are determined to be eligible for the program, after you're found disabled, rather than requiring the individual to wait 5 months to begin receiving benefits. So, yeah, it literally says here there's 10,000 people in 2017 who died waiting for their benefits. I didn't say died because of this rule, but some of those 10,000 actually did die because of this rule. Just think about that. Okay. Number 2 of the three things in pro to remove all of these waiting periods. Phasing out the 24-month waiting period for Medicare disability benefits. It's a great idea. If you're disabled, why do you have to wait 24 months to get Medicare? That to me isn't even, I mean, there's stupid, there's incredibly stupid, there's, shit-faced, how did they come up with this? And then there's, we need to donate this person to another country. And that's where that rule lives. We need to donate the person who created that rule to another country. Directing the National Academy of Medicine to conduct a study to ensure the elimination of waiting periods are resulting in better health and community living outcomes for eligible SSDI recipients and their families. That's awesome. Have a group put in place to study things so that we have a better understanding as to how these rules actually hurt these people. Okay? And it's also part of that thing that they were talking about. We don't know about these Americans, maybe they're fibbers or not, but this 5-month waiting period, if we have a National Academy of Medicine conducting a study, we'll find out who are the fibbers who are waiting and who are the ones who are dying from it. Right? They're putting something in place as a long-term model to figure it out. This legislation is endorsed by a number of patient advocacy groups and other organizations. I'm sure it is, including the ARC of the United States, Autistic Self-Advocacy Network, Center for Medicare Advocacy, Families USA, Justice and Aging, Medicare Right, a zillion places. NOSCR's there. I pay for that one. There's a bunch on here. Strengthen Social Security Coalition, Social Security Works, all of them. Okay. Now, look, here's the thing. I just want to point out, this was September 24th, 2019. So what happened to it? Right? What happened to it? I read this thing and I was like, oh, okay. What happened to it? Biden put on his website while he was applying to become president of the United States that he wanted to get rid of the 5-month waiting period, that he wanted to get rid of the 24-month Medicare waiting period. He wanted to get rid of those. That was part of his platform. Now, granted, Biden hasn't been in there that long, but we didn't need him to be in there that long because other people were already pushing for this. ALS Association. ALS Disability Insurance Access Act reintroduced in the 116th Congress. Okay, cool. All right. Bipartisan legislation eliminates 5-month waiting period for SSDI benefits for people diagnosed with ALS. We all know what ALS is. The ALS Disability Insurance Access Act was reintroduced to the 116th Congress this week as S.578 in the Senate by Senator Sheldon Whitehouse, Democrat, Rhode Island, and Senator Tom Cotton, Republican, Arizona. So like both, we all want this. We all want this. We don't even need Biden. We all want this, right? Representative Seth Moulton, I don't know how to pronounce his name, Democrat, Massachusetts, and Peter King, Republican, New York, introduced the companion bill in the House, H.R. 1407. The bill was introduced with strong bipartisan support from 40 senators and 90 representatives. That's a lot. 40 senators. 40 senators were kosher with this. They were cool. They were a class 5 bueno, all right? Last year, thanks to your advocacy, the bill gained considerable momentum. This thing's chugging along like a train. Everybody's on board. Within 3 months of the 2018 National ALS Advocacy Conference, more than 1/3 of Congress supported the bill. Within 7 months, the first time ever the bill was considered for passage through the Senate via unanimous consent. Multiple research studies indicate that people who have served in the military are at a far greater risk of developing ALS and dying from the disease than those with no history of military service. The ALS Association is honored to work with more. All right, this is just going through basically the people they work with. Okay, over the course of the 5-month waiting period, people living with ALS will have only experienced progressive loss of function, will have incurred significant expenses for care and treatment. The president of the CEO of the ALS Association stated, "We urge Congress to pass this legislation and remove the arbitrary 5-month waiting period that creates an unfair financial burden on people whose life expectancy is so tragically abbreviated." Yeah, makes sense. Okay, cool. People with ALS have earned and should receive both Medicare and Social Security disability insurance benefits immediately. They simply don't have months to wait. Nothing in there was incorrect. That is all absolutely incorrect. Senator Whitehouse said, "I am proud to co-sponsor this bill to eliminate the waiting period for those battling ALS. It takes tremendous courage from patients, family members, and friends to cope with an ALS diagnosis. I hope that as a simple act of humanity, we can set aside bureaucratic considerations and allow Americans who face the extraordinary blow of this diagnosis to immediately receive the benefits they have earned." Senator Cotton said, "ALS is a progressive and disabling disease for which there is no cure. Those who suffer from this terrible disease endure enough pain and they should be subject to the usual waiting period for disability benefits, especially given their tragically short life expectancy." And then we go on, and we go on, and we go on. Final paragraph. "There is a strong precedent for waiving the 5-month waiting period before people with ALS receive access to SSDI benefits. In 2000, Congress recognized the unique features of ALS and passed a bipartisan bill waiving the standard 2-year waiting period before people with the disease become eligible for Medicare." All right, so this is an ALS-specific document. But I want to point something out. Biden wants us to go through. It was one of his platforms on his website that he outlined, specifically wrote things about. This document, right over here, what does it say? It says, what does that say? 116th Congress. So when I read this, and where's the thing on here? When I read this, this was basically created as part of 2019. So 2019, everybody was like, we want this. We're on board with this. Not everybody, but a lot of people. And a lot of people for how this usually goes. 116th United States Congress. If so many people were on board, before Biden was elected president, 116th Congress was convened on January 3rd, 2019 and concluded on January 3rd, 2021, before Biden even became president. So where are we now? So what happened to this? Biden, everybody's on board. Where are you at? You're on board. Where are you at? This should have been like, you get into office, my intention is this. Write it up, push it through. Where are we at? You said you supported this. Past year, 116th Congress, they were pushing it. What happened? So the problem is this. This is pushing specific law for ALS. But we need a general law for all disabling conditions falling under the severity requirements of the 5-step sequential process for SSI and Ssdi. So what happened? Yes, Biden has only been in for a short time. Argument accepted. But nothing has been done. There's been no promotion of this at all. There's been no new news, updates related to it. Here's the thing, guys. When a president runs on a particular platform, they need to go ahead and push forward the agendas in the very beginning that they said they would. I understand the pandemic. I get that. But this would help those in a very significant way with seed money who are disabled partaking in the same pandemic. We need to start holding, and this is not just a Biden thing. This goes back to, it's Biden, Trump, this goes all the way back. We need to start holding our politicians accountable. We used to all make the jokes in middle school and high school. The president of the middle school, class. The president of the high school class. Wow, my goodness, that's amazing. Yeah, congratulations. And then they would do some of the things that they said, but not all the things that they said. Or it would take forever for them to roll out with them, right? Year 3 of 4, we're thinking about it. Year 4, we're sticking our toe in the water, and then didn't win. I couldn't do it. If you are specifically pushing the agenda of this particular thing, then I expect you, within the first month of your presidency, to give guidance on what's going to happen. I don't care if you have a strong plan. I just need to know you have a plan. I need to know that there is something going to happen. So I am starting to get, and we have to give everybody a fair shot. We have to give everybody a fair shot. We got to do that. When they become president, we have to give them a fair shot. But I'm starting to get a little cranky about where we're at, specifically with getting rid of this 5-month waiting period, because to be fair, everybody wants this. So what's the holdup? Well, maybe not everybody, but a lot of people. When you've got 40 senators agreeing to it, and a heck of a lot of House people, and a heck of a lot of programs, what's the problem? You want to make a big splash? You want to make the American people get more of the money they already paid into the system? What's the problem? You look great. Why are you not doing this? All right, guys, so that's why I'm not happy. That's one of the big things. It's not the number one rule that needs to be changed, but it's in the top 10 list. If you'd like an update on this, that's fine. Please catch up with me during the live session. I go live on Thursday from 8 to 10 p.m. every Thursday. We get a lot of people calling the law firm for non-law firm related stuff, so try and separate those two. If you want representation, that's fine, the law firm. But if it's like this stuff, what I make these tutorial videos about, then please just catch up with me during the live session, or shoot me an email if it's like a question that you need answered right away or whatever. in that case, reach out to me. But otherwise, catch up with me during the live, 8 to 10 every Thursday, Eastern Standard Time. Florida, right? You got Eastern Standard Time, Central Time, Mountain Time, Pacific Time. You've got Alaska Time, whatever that, and Hawaiian Time. So basically what that equates to is this. You have 8 o'clock, 7 o'clock, 6 o'clock, 5 o'clock, 4 o'clock, 3 o'clock, 2 o'clock, as you go down the line, because some people are actually watching these videos outside of the country. The point is this, guys. We need to hold these politicians, and it's not just Biden. It's these other politicians as well. It's not just Democrats. It's not just Republicans. It's not just libertarians, which is what like a lot of them are just magical. Oh, now I'm a libertarian. It's not just those. We need to hold them all accountable, because this is something we paid for. It's something that we were tricked out of to begin with and should have been given. They should not have taken this to begin with. And the arguments they used are not worthy of taking that many thousands of dollars from the American people. Now, back in the day, it was a smaller amount because so what are you going to say? Oh, it was only hundreds of dollars? Well, those hundreds of dollars bought a whole heck of a lot more back in the day than thousands of dollars will do now. So that's a terrible argument for them to make. The point is this. I haven't found a single argument yet. And they even proved in one of their writings that they're not sure about their main arguments. I haven't found a single argument yet other than they want to take money from the American people that the American people paid for. I haven't found a single argument yet as to why we should keep the 5-month waiting rule. I see unethical arguments, I see immoral arguments, but I've not seen a single argument yet as to why we should keep it. Or here's an even better one, why the private insurance companies should be allowed to have one. My name is Attorney Walter, if not the third. If you have any questions, catch up with me during the live, 8 to 10 every Thursday. If you would like something else, please catch up with me via phone, email, or text message, or fax, or snail mail. And if you would like the most up-to-date information, please catch up with me during the live. Have an absolutely wonderful night, and I'll catch up with you later. Thanks so much. Bye-bye.